Before we get started, I would like to provide you with a quick overview of WERMC, our new cooperative. It's a new 660301 formed on July 1, 2011. In other words, it's a cooperative formed to help Wisconsin's districts pool their purchasing power and knowledge to help gain the best pricing on insurance and best results on risk reduction efforts. Personally, as a former member of another co-op, I experienced the excellent benefits of both a co-op and the independent risk management consultant who now works with WERMC, Kathy Johnson. She provides timely individual service to help me and help my students and help keep the employees safe and avoid liability issues and losses. WERMC is dedicated to working only with the best insurance providers and brokers. Our workers' comp carrier, SFM, already insures 140 school districts in Minnesota and provides exceptional loss control service. Its dividend program is very competitive and yet reasonable, so it can be sustained. WERMC's workers' comp insurance agency is RJF from Eau Claire. Not only do they have years of experience working with school districts, but they also have their own claims management, HR, loss control, and health management consultants. WERMC's liability insurance carrier is Community Insurance Corp. CIC has insured my district for over 8 years. Not only does CIC have coverages and benefits others don't, but their loss control specialist, Jody Tross, is exceptional. If you know her, you know how thorough, well-informed, and well-received by employees she is. WERMC is looking for new members who want exceptional service from its carriers, brokers, and agents. The impartial advice of an independent risk management consultant and those who believe sound loss prevention efforts are the best way to reduce their injuries, lawsuits, and costs. We'll be hosting several webinars in the coming months. Already scheduled are November 2nd, New District Dynamics, Life Without Labor Contracts, and December 13th, Workers' Comp 101, Understanding How to Control Costs into the Future. Now I'm going to hand it over to Chrissy Van Berkum to begin our webinar.
And Erin, this is Kathy. I'm going to take it from you and introduce our speakers. As Erin said, when the school districts came to me this summer and asked me to help them form a new 660301, I knew exactly what I wanted from the agent and the carriers that we were choosing. And that would include the broad resources of a national insurance broker and their on-staff consultants to help us with the workers' compensation losses, and resources beyond that to include health management and human resources. Competitive dividend program that Erin mentioned, and ample loss control to be able to keep those dividends rising instead of going the other direction. We wanted a work comp carrier that also had broad resources with a computer system for claims access for the school districts and good claims management resources. We wanted the broad liability policy, and that's why we picked Community Insurance Corporation, which has an 8-year history of no rate increases. And as Walmart would say, we're doing a rollback on pricing with WERMC, the co-op, to former years of pricing in order to help the districts navigate the budget crises that they're dealing with now. So WERMC has RJF agencies, a Marsh & McLennan agency as its work comp broker. They're experienced in schools. They provide impressive services due to their broad and innovative service platform. They don't just jump into action when something bad happens. They're dedicated to helping districts keep bad things from happening and changing the culture within the school district, a challenge that we're all looking at now in Wisconsin. So if you're interested in knowing more, contact Erin or me, and the contact information will be at the end of the webinar. Now our speakers. Chrissy Van Berkum is an experienced attorney with Phillips Borowski, and she's experienced in governmental liability defense, civil rights, employment law, correctional health care, complex litigation, and appellate review. Before joining Phillips Borowski, Chrissy worked for several years for a private firm in the Atlanta metro area. As a non-equity partner at Phillips Borowski, she served as litigation defense counsel to several counties and their officials. She continued representation through the appeals process, gaining experience in appellate review. She's a member of the State Bar of Georgia, the Defense Research Institute, and the American Bar Association. She's licensed to practice law in Georgia, and her application for admission is currently pending in Wisconsin. Our second speaker is Andy Phillips, a shareholder in Phillips Borowski. Since graduating from Marquette University Law School in '95, Andy has dedicated his practice in representing the public sector. Andy is experienced in all facets of public sector labor and employment law, as well as the peculiar general business issues facing Wisconsin local governments and school districts. Andy has represented clients in Wisconsin state and federal courts, the Wisconsin Supreme Court, the Illinois state and federal courts, and the Indiana federal courts. And I would add that Andy's also a friend to school districts, providing very important guidance on issues that school districts are facing every day. So Chrissy and Andy, please present your program.
Thank you, Kathy. I think we've lost Andy due to technical difficulties, but as Kathy said, my name is Chrissy Van Berkom, and I am with the law firm of Phillips Borowski. She's given a fair overview of our firm, so I will go ahead and get to the nuts and bolts of our presentation today. As you all know, we are here to talk about guns in schools and the new concealed carry law that has been enacted in Wisconsin. The new law actually came about as a result of the Wisconsin Supreme Court invalidating most bans on concealed carry and a recent U.S. Supreme Court case called McDonald versus the City of Chicago, which clarified Second Amendment protections and extended those protections to cities in the states. As a result, Wisconsin became the 49th state to allow concealed carry, and the new law will take effect in a couple weeks on November 1st. Given that this new law is on the horizon, it's a great opportunity for us to take the time to address you, let you know what the law is, how it applies in schools, and perhaps some policy considerations that schools need to look into. So now that we have concealed carry, what about this new law coming into effect does not change about the laws currently on the books? Well, currently in Wisconsin, open carry is the law. That comes to us from the Wisconsin Constitution, where the people have a right to keep and bear arms for security, defense, hunting, recreation, and other lawful purpose. The passage of concealed carry does not impact open carry. Open carry is allowed in all places that concealed carry is allowed, including school zones. And we'll get into exactly what constitutes a school zone and what weapons are going to be allowed in those designated school zones. Licenses are not required for open carry. However, under the new law, in order to carry concealed weapon, licenses will be required. Weapons which may not be carried openly include switchblades, short-barreled shotguns and rifles, electric weapons, which is important to remember, machine guns, and silencers. So what is this new law? What does it mean for schools? How does it work? Who may carry concealed weapons? And where may those who are licensed carry the concealed weapons? Well, the new law allows Wisconsin citizens to carry concealed weapons upon proper receipt of proper training and upon issuance of a permit through the Department of Justice. Several individuals who are interested in applying for permits have questioned whether or not they can go through local law enforcement agencies to obtain permits, and under the new law, that is not the case. The DOJ has sole possession of issuing permits. Now, once an individual receives a permit, he or she will be able to carry concealed weapons in most public buildings, which include city halls, firehouses, community centers, and other community buildings, unless an entity has made a decision to prohibit weapons and has posted a sign prohibiting that practice. What does the new law change? Because the exemptions, which we will get into later, allow for carrying within school zones, it's important to recognize what these changes are in the new law. Well, now weapons may be carried hidden from the public view under coats, in the waistbands of pants. Weapons will no longer be visible to the naked eye. Electric weapons is one of the big categories that has changed. Prior to the law, prior to this new law, no one was allowed to carry electric weapons openly, aside from law enforcement, correctional officers, and military personnel. Now, under this new law, those who are licensed are able to carry concealed electric weapons. And the big thing that has changed that is important for our purposes today is that the Wisconsin Gun-Free School Zones Act, which again I'll get into later, now provides an exemption for persons who do carry a valid concealed carry permit. Under the new law, there are several locations which are prohibited by the statute. Those include law enforcement facilities, police stations, sheriff's offices, state patrol stations, jails, prisons, correctional facilities. There's secured mental health facilities that are specifically defined by the statute that are also prohibited concealed carry locations. Courthouses, all state, federal, and county courthouses, weapons will be banned. This includes those areas that are used as municipal courts while the court is in session. Any areas beyond security checkpoints are also a prohibited location for concealed weapons. As I mentioned earlier, in order to carry concealed, one has to obtain a permit from the Department of Justice. In order to obtain a permit, well actually in order to apply for a permit, I should say, an individual must be at least 21 years of age, a resident of the state of Wisconsin. The individual must not have been prohibited by state or federal law from possessing a weapon, or prohibited by a county, state, or federal court from carrying a weapon while on bail or release and facing charges. The individual must pay a $50 application fee, and the permit will be good for a period of 5 years. The DOJ also mandates that an individual applying for a permit must take a weapons training course. Unfortunately, the training that is required has not yet been defined. We are awaiting for parameters to be established by the Department of Justice, but we have not received word what exactly those training guidelines will look like. There has been talk within the past week that Governor Walker would like to see a 4-hour training session, but as far as the curriculum is concerned, we don't know what that looks like yet. So who is it? Who are the individuals that will receive these permits? Well, as long as those above requirements are satisfied, the DOJ will issue a concealed carry permit. Unfortunately, the list of licensees is not public record, so schools will not have the ability to have a list of all those within their district or within the area of the school as to who has a permit. Now, the statute dictates that law enforcement may ask to see an individual's concealed carry permit. It does not indicate whether or not an individual business or a county or a school or even an individual, him or herself, can request to see a concealed carry permit of somebody who is carrying concealed. We'll get into this when I talk about policy considerations, but I do believe that schools will be able to ask individuals who are carrying to see their permit and to verify that that individual does indeed have a valid permit. However, this is an area where schools will have to exercise some caution, as we don't want to run into a situation where schools are then seen to be infringing upon individuals' constitutional rights. Like I said, I'll get into that a little bit later when we talk about policy considerations. As I mentioned, as far as who may carry, there's the permit process. You got to be 21, you must have the training, and you can't be prohibited by state or federal law from possessing those weapons. Big question is, what weapons are going to qualify under concealed carry for purposes of carrying? Those weapons are handguns, knives, excluding switchblades, billy clubs, and electric weapons. The most common electric weapon is tasers. And those 4 specific weapons are the only ones that are enumerated under the concealed carry statute. Therefore, weapons such as long guns, switchblades, short-barreled shotguns or rifles, machine guns, and silencers are still prohibited under concealed carry, just as they are under open carry. Now we get to sort of the meat of the presentation as far as schools. What about schools? How does concealed carry affect schools? Well, generally speaking, a licensee may carry a concealed weapon anywhere in the state except as provided for in the Federal and Wisconsin Gun-Free School Zones Act. Now, the Wisconsin Gun-Free School Zones Act prohibits firearm possession within 1,000 feet of the grounds of a school, subject to a few exemptions, one of those being individuals who have been licensed under the new concealed carry law. Before I get into the details about what the Gun-Free School Zones law is, I think it's important to realize what the congressional intent was in enacting these laws. From a federal perspective, Congress found the need for a Gun-Free School Zones Act based on a few factors. First and foremost, they recognize that crime is a nationwide problem. I don't think that is any secret. It was fairly obvious that crime rates have been increasing through the years, and that crime has been exacerbated with the movement of drugs, guns, as well as individuals throughout our nation. Congress also found that firearms and also ammunition for firearms were found in increasing numbers around schools. This resulted in the occurrence in violent crime increasing, and Congress also recognized a decrease in the quality of education of the children of our country. And this decline in the education, as most know, has had a negative impact on our nation as a whole and our nation from a global perspective. And because states, localities, and local school systems were finding it almost impossible to control gun-related crime by themselves based on those Second Amendment rights I mentioned at the beginning of the presentation, Congress felt that it was necessary to enact a measure that would ensure the integrity and the safety of our nation's schools. So armed with this information and research, there were several reports of the different committees in Congress. The federal government enacted the Gun-Free School Zones Act of 1995. Now, take a step back. In 1990, this gun-free school zones was sort of first on the table, and the Supreme Court struck down the original version because they found that Congress did not have the authority to regulate guns in schools. Fast forward 5 years, and a few changes were made to the statute, and the Gun-Free School Zones law was enacted and is still intact today. The federal law prohibits any individual from knowingly possessing a firearm at a place the individual knows or has reasonable cause to believe is a school zone. Again, I'll get into the definition of a school zone in just a moment, but the prohibition against firearm possession in a school zone does not apply to private property not part of school grounds, an individual licensed to carry a firearm, a firearm that is not loaded and is in a locked container or locked firearm rack on a motor vehicle, an individual who has contracted with the school to carry a firearm on school grounds, to law enforcement officers who are acting in their official capacity, and to an unloaded firearm that is possessed by an individual who has been authorized to hunt on public or private lands if the school has authorized that individual to access those lands. Also included in the law is a prohibition against discharging or attempting to discharge a firearm in a school zone. And again, this prohibition does not apply to private property as part of a program approved by the school, by an individual in accordance with the contract, and by law enforcement personnel acting in their capacity as law enforcement officers. To truly understand this new law, it's important that we define a couple terms. First and foremost, what is a school? What does Congress consider to be a school, and what schools fall under the protections of the Gun-Free School Zone Act? Well, the federal law does not have a definition contained within it for a school, but the Wisconsin legislature has defined a school as a public school, parochial or private school, or tribal school, which is defined by statute, which provides an educational program for one or more grades between the grades of 1 and 12, which is commonly known as an elementary school, middle school, junior high school, senior high school, or high school. So essentially, this definition is what most individuals think of when they think of a school. We all know it's the Gun-Free School Zones Act. So what is a school zone? A school zone is in or on the grounds of a school or within 1,000 feet from the grounds of a school. And as you can see, this definition is pretty vague because what exactly constitutes grounds of a school? Well, once again, the Gun-Free School Zones Act is silent on the issue. Both the state and federal Gun-Free School Zones Act, I'll get into the state act in a moment, fail to define the term. Further, the Supreme Court of the United States has not defined the term, and when they've had the opportunity to do so, the Supreme Court has passed on coming up with any definition of the term. Wisconsin courts have yet to define the term, but what they have found is that school grounds do include the areas of the school where school officials have dominion and control. Obviously, this would include school buildings, anywhere where classes are held, places where activities happen, football fields, auditoriums, things of that nature. Courts have also supported the inference that school grounds include the school parking lot. Now, under the federal Gun-Free School Zones Act, the legislature recognized that, generally speaking, schools are under the control of the state, and therefore the federal statute provided for states to enact specific gun-free school zones laws on a state-by-state basis. Armed with this, Wisconsin enacted their own gun-free school zones law, which mirrors the federal law. It prohibits individuals from possessing firearms on the grounds of a school or anywhere within 1,000 feet of the grounds of the school. That language, as I said, mirrors the federal law. The prohibitions also mirror the federal law. It includes those who are, the prohibitions include those who, those individuals who possess a firearm in accordance with the federal statute. It also includes state-certified game wardens. Again, those weapons that are locked and encased in a locked firearms rack or a locked motor vehicle, and those individuals who are legally authorized to hunt on school grounds. The Wisconsin statute also includes the provision regarding discharge of a firearm in a school zone, and the same prohibitions apply there. Now that you have a sort of historical perspective on the Gun-Free School Zones Act and have an idea of what exactly the Gun-Free School Zones Act is, it's important to look at how the new concealed carry law in Wisconsin interacts with the Gun-Free School Zones Act. How does concealed carry fit in schools? Well, under the new law, individuals may not knowingly possess a firearm, concealed or otherwise, in or on the grounds of school unless it falls under one of the following exemptions. Again, the firearm is not loaded and is encased or in a locked firearms rack that is on a motor vehicle. The person is a state certified warden. The person is legally hunting on school grounds, or the firearm is being used in a program approved by the school. Now, an individual may not knowingly possess a firearm within 1,000 feet of the grounds of the school unless the individual has a valid Wisconsin concealed carry permit or the individual is carrying the weapon on private property. That means if an individual does have their concealed carry license, if they are within 1,000 feet of the school, that is okay under the new law. However, the ability to carry concealed weapons does not apply to dangerous weapons within 1,000 feet of the grounds of a school. Now you're probably wondering what are those dangerous weapons? Well, once again, we are waiting for the Department of Justice to define that term. They have been given the authority under the statute to come up with a definition of dangerous weapons and what exactly is included in that category, and we are still awaiting word from the Department of Justice. One other point I need to make is that the federal exemptions that we talked about previously apply under the new concealed carry law. Now, you may be asking yourself, well, what can we do given the new law? How can we prevent licensees from carrying weapons on school property? Can we post notice? Some of you may be aware that there are provisions in the new law that allow private entities and public entities to post a sign informing the public and their employees that concealed carry is prohibited in certain locations. Well, under the new concealed carry law, schools may not post notice. The new concealed carry law does not specifically authorize schools to post signs that say that the school prohibits concealed weapons on their premises. Thus, if school employees or third parties are licensees under the new law, nothing in the law will allow a school to ban weapons in personal vehicles that are within 1,000 feet of school grounds. And therefore, because schools are unable to post notice prohibiting weapons, school employees are allowed to have them in their personal vehicle. Schools may prohibit employees from carrying weapons during the course and scope of their employment with the school. For instance, if an individual teacher is running an errand or conducting school business in any manner and is in a school vehicle, that individual may be prohibited from carrying a weapon with him or her while conducting school business. However, if that individual employee is in their own personal motor vehicle, a school may not prohibit concealed carry in the personal vehicle that is driven. A school may not prohibit concealed carry in personal vehicles that are used in the course of employment. As I mentioned earlier with the individual teacher who is running an errand for the school, if they're in a school vehicle, that's fine. The school can prohibit concealed carry. If the individual is conducting that business in their personal vehicle, the individual may have a concealed weapon on them at that time. So given the fact that employees may have concealed weapons in their vehicles, what can a school do? Well, schools can take some precautionary measures and establish regulations with respect to the storage of concealed weapons. For instance, a school may require that weapons that are kept in personal vehicles are unloaded and encased or out of sight in a locked gun rack or in a locked vehicle, perhaps with the trigger lock engaged. There are a number of things that schools can do, even though they cannot prohibit those weapons, but to try and regulate how those weapons are stored in personal vehicles. Now, given that brief background on the law, I just want to go ahead and clarify and emphasize a couple of points on concealed carry. As I said, individuals may not knowingly possess a firearm in or on the grounds of a school unless one of the exemptions applies. And an individual may not knowingly possess a firearm within 1,000 feet of the grounds of a school unless the individual is on private property or the individual has a valid concealed carry permit. So taking those points into consideration, schools are now left with the task of developing policies that comply with the new concealed carry law. One of the things that a school can do is establish a verification procedure for asking individuals to demonstrate compliance with the permit process and the license process. This may simply be an authority given to a supervisor who at the school, perhaps the principal or the assistant to the principal, who will approach an individual and ask that individual for their license and their photo ID to verify that the license is indeed valid and that person can carry. Well, then what can be done? If the individual has a valid concealed carry license, essentially that ends the inquiry. That individual may have the concealed weapon on him or her. If the individual is not properly licensed, this is where schools will need to prepare plans with local law enforcement for how to handle those violations. And that's, like I said, schools are going to have to work hand in hand with law enforcement to do that. Schools will want to assess any security issues with concealed carry. Are there multiple entrances to the buildings of schools, to grounds of schools that perhaps are going to be an issue? Any enforcement plan that the school develops should be discussed hand in hand and in conjunction with local law enforcement. Once these considerations are accounted for and addressed, it's time to prepare the policy. And although it likely was not the intent of the legislature to allow individuals with concealed carry licenses to carry within 1,000 grounds of the school if they had a license permit, that's where we're at with the new law. And although the Department of Justice or the state legislature will likely clarify some of those provisions, that's what we have before us now, and schools will enact their policies in accordance with the laws that currently exist. Any policy that a school creates could have the following components to it. As I mentioned earlier, for vehicles that are in parking lots or on grounds that are within 1,000 feet of school property, schools can require that those guns be encased or unloaded in locked cars and out of sight. Individuals who are in possession of concealed weapons in areas not prohibited, where concealed carry is not prohibited, still must comply with applicable local, state, and federal law. And this is something that schools will just want to make their employees aware of within the contents of their personnel policies. No employee may carry a weapon while acting as an employee of the school, except for in their own personal vehicle. Another policy component is that employees must adhere to the policy of any other employers or property owners at any alternative sites. Mentioned earlier the scenario of an individual teacher who is on school business, off school property. If there are policies in place at other businesses or other premises, the individual school employee must abide by those policies as well, in addition to the school's policies. Another consideration for schools is enforcement of prohibited conduct. That should be included in policies as well. What is going to happen to enforce the concealed carry prohibitions? Calls to local law enforcement will most likely be the course that is taken by many of the school districts to hand that issue over to local law enforcement for individuals who are in violation of the law. But these procedures will want to be worked out ahead of time in the schools. In order to implement that new policy, schools are going to want to brief all employees on the new law and any policy components that the school develops. They'll want to update student policies and communicate those policies to the parents, as well as some of the older high school students, if that may be the case, to update them on the new law and the new policies. Schools will also want to monitor and assess instances of concealed carry and keep a lookout for any potential problems that may begin to present themselves. Given the fact that individuals may carry within 1,000 feet of school grounds, if you have public or private property that is within 1,000 feet of the school grounds, what issues may come up that need to be addressed by the school? Just something that needs to be taken into consideration. What are the litigation risks that schools face as a result of the new concealed carry law? Well, schools have a duty to reduce violence in schools, and this can be accomplished through inspection and monitoring of not only the students, but also any individuals who are coming onto school property. Schools also have a duty to ensure a safe educational environment, and in order to provide a safe educational environment, we must continue to educate our students on safety as well as faculty and staff. And again, this can be conducted through education and also through inspection and monitoring. One of the biggest areas for concern is the infringement on the constitutional rights of individuals. Because schools are apparently unable to post signs prohibiting concealed carry, schools must be careful not to infringe upon the rights of individuals who are legally carrying under the new law. As I mentioned, some regulations may be placed by the school on employees who have weapons in their own personal vehicles, and schools just need to ensure that they don't go too far with those regulations that are in place. A couple common scenarios that schools may run into. An individual carries a concealed knife onto school grounds. Is this allowed? Well, no, it's not. Even though the individual may have a valid concealed carry permit, that individual is not allowed to carry on school grounds unless one of those statutory exemptions that I mentioned earlier are in existence. Those for local law enforcement officers, state wardens, individuals who are contracted with the school to do so, those types of exemptions. What about carrying a concealed handgun onto school premises and somebody who is legally licensed to do so? Well, again, that individual is not allowed to bring a handgun on to the premises, unless one of those statutory exemptions exists. What about electric weapons? Well, first off, with electric weapons, this would include something such as a taser or a stun gun. Typically, the electric weapons are not weapons that actually will cause death. They have the potential to cause serious bodily injury, but electric weapons are those that usually stun an individual or momentarily give them a shock that will prevent them from any further movement. So with an electric weapon, are those allowed on school premises? Well, no, these aren't either. Electric weapons are not allowed to be openly carried, and they are also not, and although they are allowed to be carried concealed, those are not allowed on school grounds either. So given the landscape of the new law and given the landscape of the federal and state gun-free school zones laws, are schools safer with this new concealed carry law? Honestly, it probably does not alter safety concerns of schools. Regardless of whether or not an individual is allowed to carry a concealed weapon, schools are always mindful of the safety and security of the students and the integrity of the school system. Measures are likely already in place at many of the schools to deal with weapons that are carried in the open in situations where individuals bring weapons into the schools. However, an argument I think can be made that schools are actually less safe now with this new law because individuals are allowed to conceal the weapons. It makes it more difficult to detect when somebody is armed, and it raises into question additional considerations with respect to potential litigation risks, which I mentioned earlier. Does the new law open the door to any legal challenges? Well, it appears it will. As I mentioned, it likely was not the intent of the legislature to allow Wisconsin licensees to carry within 1,000 feet of the school grounds. That issue, I think, is ripe for litigation, both at the state and federal levels, given the state and federal Gun-Free School Zones Act laws that prohibit weapons within 1,000 feet of school grounds. Is the law in conflict with open carry? Perhaps it is. Concealed carry allows a little bit more leeway to public and private entities who want to post notice prohibiting weapons. And so perhaps concealed carry is a little bit more restrictive than open carry, and the two are in conflict a little bit, and that's another issue which may open the door to legal challenges. That concludes the presentation on concealed carry and guns in schools. I'm not sure that we have any questions for anybody. Can wait a few moments and see if anybody has any questions.
Kathy, this is Jeff. We had one question come in electronically, and that was about exactly what an electronic weapon is that you mentioned earlier in the presentation. If you could just expand on that a little bit and let people know what that is.
Sure. I mentioned it a little bit in talking about common scenarios that may be encountered. Electric weapons, the most common one we think of are tasers. Those are weapons, as I mentioned, they typically do not cause death, although they have been known to do so. They typically do not cause serious bodily injury, although they have been known to do so. Tasers and other electric weapons typically stun an individual and render them momentarily unable to move, It subdues the individual so that somebody is able to take control of that individual. A lot of times electric weapons are used by law enforcement to deal with an unruly suspect, to get them to submit to the law enforcement officer's control so that they may be placed under arrest. Like I said, they're weapons that typically don't cause serious bodily injury or death, but they sometimes do, the most common one being a taser. Are there any other questions?
If not, I would just like to remind people of our upcoming webinars. New District Dynamics Life Without Labor Contracts, November 2nd at noon, and Workers' Comp 101, Understanding How to Control Costs, December 13th, again at noon. Hopefully there's a slide showing next that will give the contact information for Kathy Johnson and Aaron Green on your screen. And I'd like to remind people that this session should be available via a web link that will be sent to you to listen to again or pass on to others through the end of this calendar year.
And Kathy, I just wanted to mention one more thing that to the school districts that we have present today. It's really hard to give a definite policy to the schools to comply with the new concealed carry law. Each individual district is going to want to look at their situation on an individual basis, look at their possible exposure to any litigation claims or any issues that may arise as a result of concealed carry, and come to a policy decision on a school-by-school basis. And with that, if anybody does have any questions concerning the law itself, feel free to contact Andy or I, and we'd be happy to answer any questions that individual districts may have.
Thank you all for attending, and that concludes the webinar.